Hi, everyone. I'm going to get started here. My name is Dr. Shreya Mandava. I'm an ENT resident and a Capello Advocacy Fellow at DFA. I want to welcome you all tonight to tonight's session on federal preemption and its impact on state restrictions limiting access to mifepristone and abortion care. Before we get started, I want to take a quick minute to invite you all to officially join Doctors for America. Being a DFA member today means taking the important and simple step of selecting a membership level and paying your annual membership dues to support our organizational sustainability and incredible programs like this Advocacy Grand Round series. We're also currently offering a promo code, ENGAGE, in all caps, which you can use to get 20% off your first year of membership. A DFA member will put the link in the chat to join very shortly. Additionally, we will be live streaming this event to Facebook Live and making a recording, which will be available after the session. A few quick ground rules before we jump in. One, there is no such thing as a stupid question. And two, speaking of questions, please remember to use the Q&A feature since this is a Zoom webinar. We will be addressing questions towards the end of the session. Also, please look out for any comments in the chat. We have DFA staff members on who'll be sharing helpful links during the session. Now on to what we've all been waiting for, our wonderful speakers. We're thrilled today to welcome Skye Perryman, Chris Morton, Claire Huang, and Isaiah Levinson. Skye Perryman is the president and CEO of Democracy Forward, a nonpartisan national legal organization creating progress through litigation, regulatory engagement, policy, education, and research. A seasoned litigator and strategist, she's led efforts against abortion bans, book bans, civil rights rollbacks, and more. She's also served as general counsel for the American College of Obstetricians and Gynecologists, where she spearheaded legal strategies that led to mifepristone mail distribution during COVID-19 and expanded postpartum Medicaid coverage. Thank you for being here tonight, Skye. Next, we have Chris Morton. Chris is a lawyer who currently teaches at Columbia Law School. He's the director of Columbia's Science, Health, and Information Clinic, or SHIC, which represents DFA pro bono. Chris's clinical work, research, and writing focus on access to knowledge with an emphasis on science, technology, and health justice. He also seeks to expand access to medicine and information about medicines. He holds a PhD in organic chemistry on top of his law degree. Thank you for being here, Chris. And last but not least, we have Claire Huang and Isaiah Levinson, who are both students at NYU Law. Claire is a second-year law student who's a licensed doctor in Taiwan and obtained a master's degree with a focus in epidemiology prior to medical and law school. Isaiah is a third-year law student and previously worked as a paralegal with an FQHC, helping queer and low-income community members navigate barriers to healthcare. Claire and Isaiah both joined SHIC to help DFA on work related to promoting gender-affirming care shield laws, upholding the integrity of the FDA drug approval process, and preventing mifepristone bans through the legal argument of federal preemption. On the topic of which, I will now turn it over to Skye to present on the legal landscape of abortion care in 2025.
Well, hi, everyone. Thank you for having me. It's such a delight always to be with this group, and I would just want to thank you all before we get started. I have a colleague on, Armand, who will help me with my slides, but I just want to say before we get started on the legal pieces, and please do liberally provide questions, and you can just let me know as there are questions and we'll answer them. I just wanted to say thank you for all the work that you all do every day on the front lines of medicine and communities in this country. It's work that's so essential, that has become even more essential in these times in the post-Dobbs era. And of course, as we are looking down the calendar here at what we're going to face in 2025, we know it will be even more essential. So I will start with just a bit of an overview of kind of where things are as we're facing the next year in this post-Dobbs landscape, and talk a bit about the role of federal preemption, which I'll just define. I think most folks that are on the webinar are quite familiar with these concepts. But when we talk about federal preemption, what we're talking about is a provision in our Constitution in the Supremacy Clause that makes clear that the United States is one country, not 50 countries, but it is one country. That when federal law is enforced, and it conflicts with state law, it is the federal law that takes precedence over or preempts the state law, that there are constitutional and other federal law protections that protect all people in this country, regardless of what zip code they're in, regardless of what state they're in. And that is from our Supremacy Clause, which is in the Articles of the Constitution. So when we talk about federal preemption, that is what we are talking about. We also have a very robust states in this country and state law in this country, but our Constitution is very clear that when federal law and state law conflicts, or when there is an obstacle to that federal law, it is the federal law that is the supremacy, the supreme law of the land. So that's what we talk about when we're talking about federal preemption. And in the time since Dobbs, where the Supreme Court really removed a major federal protection for abortion access, which is our privacy protection, there has been a lot of focus on what federal rights are still available for people in this country. While the Supreme Court overturned Roe versus Wade and overturned a privacy protection that enabled people to be able to terminate a pregnancy at various stages, Dobbs did not do anything to disturb other federal rights that exist in our country, whether by Congress or whether in our Constitution. It didn't do anything to overturn, for instance, rights to free speech that exist in our Constitution, and it didn't do anything to overturn federal legislation and legislative and regulatory structures that have existed. And so that's when we talk about federal preemption and its impact on state restrictions. I just wanted to ground us in what we're talking about, which is the ultimate foundation in our country, that it is our federal law, our federal Constitution, and the laws that Congress passed that are the supreme law of the land. And that preempt state restrictions, even in a post-Dobbs landscape where, of course, there are many state and local restrictions on abortion access, which many of you are facing in your everyday practice and in your everyday lives. So I can provide certainly an overview of where we are as we move into the next year, where we're going to face a changed federal landscape and a continually complex state landscape. And then I know that some of the other panelists will speak as well, and then we can perhaps have some time for questions and discussion. So let's move to the next slide. So in the time since Dobbs, and I do think it's important for us to remember, and of course, those of you that are on the front lines know this, that even prior to Dobbs, there were millions of people in this country that were living in a post-Roe world because of the nature of restrictions on abortion access that has long been in communities across the country. But certainly Dobbs made that worse and enabled a situation where many states have restricted or outright banned abortion. And right now we have around 13 states in the country. And of course, because of the Missouri ballot initiative, which we're very pleased that passed, protecting reproductive health care access, we're about to be 12 states that have largely outright banned abortion. Some of those states have banned abortion at 6 weeks and others later in pregnancy. The life and health exceptions that exist, including in states like my home state of Texas, are vague and they are insufficient. They are causing harm. There are many physicians in states, even in states where the bans have these life and health language in their exceptions, that are not able to provide the care that they believe their patients need because of enforcement landscapes. We are seeing, with respect to medication abortion, which we know, of course, is a very commonly used and safe and common method of abortion, new attacks in Louisiana. And now we're already seeing news about bills that will be introduced in the next legislative session in Texas, in my home state. We're seeing bills that are seeking to classify mifepristone as a controlled substance or subject to a controlled substance scheduling. And then, of course, we've already seen restrictions on the right to travel in certain states. That said, there are a number of states that either through their state constitutions or through state legislation are protecting at the state level the right to terminate a pregnancy, the right to provide medical care as needed. And then we've also seen a range of initiatives be introduced that are seeking to restrict access to health care, including to medication, abortion, and mifepristone access. I will say before we get to the bans across the country, just the importance of telehealth as a method of being able to access care in this country, medical care in this country, including reproductive health care and medication abortion care. In the COVID-19 pandemic, a number a restriction was lifted that the federal government had imposed an in-person restriction on mifepristone that enabled the ability to prescribe mifepristone to the extent that it was appropriate by physicians and other healthcare professionals via telemedicine. The data that was demonstrated in the pandemic showed that, of course, it was very safe and effective, as data had long demonstrated in other clinical trials and studies. And in 2021, the Biden administration lifted the in-person restriction on mifepristone and enabled that telehealth access, which of course is something that has now been attacked by extreme and anti-science organizations. This is just a demonstration that you see on the slide of what the landscape looks like post-Dobbs, and you do see that in many states in the country, abortion is nearly fully banned and very severely restricted. And of course, many of you are living that, and I know in the practices that you have as physicians and healthcare professionals in the country. We can go to the next slide. So, there are several implications and sort of things that we're looking at when we look at the context of the accessibility of medication abortion in the post-Dobbs era. And I'll start with this AHM case that I spoke to some of you about at the Doctors for America conference in Washington recently, and that we can review here, which is that it's an extreme organization, and of course, they've been dismissed for lack of standing, but now state attorneys general are seeking to maintain this action in Amarillo, Texas, and in the Fifth Circuit, that are challenging the way that FDA has regulated mifepristone, and especially challenging the telehealth provision, the lack of an in-person dispensing requirement on mifepristone. So we saw several years ago a case filed in Texas by a special interest group that is part of the kind of Project 2025, very far right sort of organizations, filed a case in Amarillo, Texas, seeking to both challenge the approval of mifepristone for early pregnancy termination, as well as the way that FDA was regulating that medication, including through making it accessible via telehealth. The case went through a range of decisions and appeals. And in the last Supreme Court term, we saw the Supreme Court in a 9-0 decision actually issued a decision suggesting that and holding that the Alliance for Hippocratic Medicine actually did not have standing to bring the suit, that the organization that was very sort of, I think, pretty strategically founded in order to challenge this actually had not shown harm sufficient enough to bring the suit. The case should never have been in the courts. And that was a pretty significant decision from the Supreme Court, because you did have a district court in Texas, as well as the Fifth Circuit Court of Appeals, that was seeking to maintain this litigation. And the fact that even this Supreme Court, the Dobbs Supreme Court, felt that the AHM case and decided that the AHM case was really not a case that should have ever been in the court, shows you the extremism that we're seeing in some of the lower courts, including in district courts in Texas and in the Fifth Circuit. The court, however, didn't make any rulings about any other aspect of the case. It dismissed it on this procedural standing ground, which essentially means that on the merits of the case, there's nothing that has been decided. And there are various state attorneys general that are still trying to prosecute this case and to bring this case and to limit access to mifepristone throughout the country and to question the Food and Drug Administration's authority. So we can move to the next slide. So in that case, the case is now back at the district court, and there are a range of state attorneys general now prosecuting the case since the AHM organization has been found without standing. The reason that I bring this up when we're on a webinar about the relationship between federal preemption and state restrictions is that Congress has long empowered the Food and Drug Administration to be the sole drug regulatory authority in the country. And we are governed by one Food and Drug Administration, not 50. There is one federal Food and Drug Administration that makes conclusions about what is safe and effective for use. And so with respect to our medications. And so when states seek to displace that and special interests seek to displace that expertise, that is a real threat to the federal rights and privileges that all Americans enjoy, that Congress put in place with respect to the FDA. So we're still watching that AHM case. Of course, the Department of Justice under the Biden administration has done a great job defending the authority of FDA and the expertise of FDA in approving and regulating mifepristone. And as we look to 2025, there's a real question as to whether, of course, a Trump administration's Department of Justice would do the same thing. And so that's going to be a case to watch and to see sort of what the federal government will do in that case. There are several other, we can just go back to the slide just for a second, Armand, that there are several other cases that are related that deal with federal preemption. And I'm really grateful for the work that Doctors for America has done, both in the AHM cases and in other cases. There are challenges that that some states have brought with respect to FDA's REMS requirement. And then there are challenges that have been brought in West Virginia and in North Carolina, and I'm one of the lawyers on the challenge in West Virginia. And so I'll talk about that case and a bit about the North Carolina case, both of which are at the Fourth Circuit Court of Appeals. But post-Dobbs, of course, a range of states moved to restrict or ban abortion care or medication abortion care. And in West Virginia, the state is maintaining a series of regulations and laws that essentially ban mifepristone in the state for the use of pregnancy termination, which is what, of course, FDA has approved it for. Those regulations and laws that the state of West Virginia is maintaining conflict with Congress's longstanding judgment that empowers the FDA to enable and to regulate drugs in this country. FDA, of course, has approved mifepristone and is regulating mifepristone for the early termination of pregnancy. And in West Virginia, essentially, people can't access that medication for its purpose because of the laws that the state is maintaining. As I said at the beginning of this webinar, in our country, we have one FDA, not 50, and our Constitution makes clear that when federal law conflicts with state law, it is the federal law that preempts or that is supreme in that conflict. And so we are currently litigating a case that is now in the Fourth Circuit, challenging the state regulation and restrictions on abortion access in West Virginia as unconstitutional, not because it violates a privacy interest. The Dobbs decision sort of removes that tool, but because it violates the supremacy clause. And then in North Carolina, of course, there is a case that a physician is maintaining there because in North Carolina, the restrictions on mifepristone that the state is maintaining conflict with or an obstacle to the way in which FDA has regulated the medication. So those are really critical cases to watch and are on appeal at the Fourth Circuit right now. Next slide. But we know that while the post-obs world presented complications, even with the federal landscape and a president that was more hospitable to the ability of people to access reproductive health care. As we look into 2025, and we have an incoming administration that has historically, President Trump has been quite hostile to abortion access. And of course, when we look at plans like Project 2025 or other plans that have been publicized, we see a range of threats to reproductive health care, to health care overall, and of course to abortion access. There are a number of threats that we are concerned about. So I just listed some on this slide. One would be that there could be bans on abortions that would restrict access nationwide. That could occur, of course, if Congress were to pass a national ban. But it could also occur if the Department of Justice, which would be controlled, of course, by or led by people that are appointed by the Trump administration, misapplies longstanding, very old laws such as the Comstock Act that many in the far right ecosystem are arguing requires that could be enforced to ultimately penalize either telemedicine abortion or abortion overall. We believe that's a misapplication of the law, but it is a big threat, and it is spelled out in Project 2025. In addition, of course, the head of the Food and Drug Administration is a person that is appointed by the president and confirmed by the Senate. And there are concerns that the incoming administration would seek to politicize the FDA and to install people that may be hostile to science and evidence, and that could seek to reverse the longstanding scientific judgments of the FDA with respect to mifepristone and its safety and efficacy. As some of you are following, and I know some of you practice or at least have practices that overlap with emergency medicine. For many decades, the United States has recognized that if someone presents to an emergency room and is in a critical condition, there is an obligation in this country to stabilize that patient and to provide care that stabilizes that patient. That is under the Emergency Medical Treatment and Labor Act, EMTALA, which was actually a law that was signed by a Republican president and has long enjoyed bipartisan support. But actually post-obs, there were a number of states that sought to deny access to abortion or pregnancy termination in those emergent circumstances, even though federal law requires that care be provided. And so the Biden administration, the Department of Justice, of course, brought a case against Idaho, which was one of the states that was maintaining a ban that did not contain sufficient exceptions to enable all people in this country to access the medical care that they need, even in emergency pregnancy conditions. That case has been up at the Supreme Court. Many of you are following it. Many of you have practices that are implicated by it. But there is, of course, a concern that under a Trump administration, the way that they interpret EMTALA and the way that they will seek to and that they will not seek to defend the rights of all people under EMTALA. We are also incredibly concerned about privacy and medical privacy and the weaponization of certain agencies or data collection activities against people who are seeking health care. And then, of course, there was a range of sort of smaller regulatory actions that are really significant for people and communities, but that didn't get like headline news that the Biden administration helped advance, including with respect to veterans and making reproductive health care more accessible to people that rely on VA benefits, as well as other regulations that made abortion access or reproductive health care access more accessible to certain populations of people, that we are very concerned that the incoming administration will seek to overturn or otherwise restrict. So those are some of the things that we see coming down the pike. Next slide. think it's just a discussion, right? The next slide is just a discussion slide. So those are some of the areas, and happy to talk more specifically about preemption, or also about sort of how we see these next threats sort of dovetailing with that after the further panelists are able to speak.
Thank you for that overview, Sky. Now we'll turn it over to the SHIC team to give an overview of relevant legal cases and DFA's work in this area.
Terrific. Can you all hear me okay? I think I'll lead off for the SHIC team. I'm also going to share some slides. Let's see if I can get this to work. Are you seeing my slides now, hopefully? Good, I saw a nod from Shreya. So thank you, Shreya. Thank you, Sky. It's really an honor to be here. Sky, thank you so much for all that you and Democracy Forward do, and then for that terrific broad overview of legal battles over abortion throughout the country today and in the year to come. Like Sky, I'm a lawyer. I direct a clinic at a law school, the Science, Health, and Information Clinic, or SHIC, at NYU and Columbia Law Schools. My colleagues Isaiah and Claire are student attorneys in the clinic, and they're going to be speaking right after me. The clinic is a health justice clinic, and we represent patient groups and researchers and activists, all pro bono. And we also represent Doctors for America. And our presentation is going to be a little more specifically focused on the law of preemption and why it should matter to clinicians. How clinicians can get involved to protect legal access to medication abortion. And we're going to talk about how Doctors for America has already gotten involved in the challenge to West Virginia's abortion ban that Democracy Forward and Sky are involved in, as well as another case that we'll describe in just a second. A quick disclaimer, to be clear, we represent Doctors for America, but tonight we're speaking in our personal capacities, not necessarily on behalf of the organization. And with that, I'll pass the mic to Claire.
Thank you, Chris. So we're going to discuss two cases that Sky touched on called GenBioPro and Bryant. These two cases will directly affect only two specific states, West Virginia and North Carolina, rather than the entire country. But they are worth watching because the legal precedents set in these cases will affect access to abortion in other states with abortion hostile legislatures and governors' offices that have already used state law to restrict access to mifepristone. As of October 2024, medication abortion is banned in 18 states and limited in another 10 states. So these two cases would potentially affect all of these 28 states. What's currently happening is states are getting bolder about trying to ban FDA-approved drugs. In the past, the law was clear that states couldn't do that. Only the FDA can undo the FDA's own decisions about whether to approve a drug. But Dobbs and the emboldened anti-choice movement have reopened this question. So GenBioPro and Bryant concern the question of whether a state can ban an FDA-approved drug. Doctors for America's work in these cases is in large part about protecting the regulatory power of the FDA in the face of state governments that want to second guess and override the FDA's decisions. And GenBioPro and Bryant are worth watching because they're important examples of how the pro-choice movement and how progressives can still use the courts to our own ends. In other words, not all litigation is defense, and we can still do offense in federal court. So let me tell you what the GenBioPro and Bryant cases are about. In 2022, shortly after Dobbs, West Virginia's legislature and governor enacted a de facto ban on abortion with minimal exceptions. The ban covers all forms of abortion, including medication abortion. So clinicians in West Virginia are now sharply limited in their ability to prescribe mifepristone. In January 2023, GenBioPro, which is a generic manufacturer of Miffy, filed a lawsuit against the state of West Virginia to challenge the ban. GenBioPro brought suit in federal court and challenged the state ban as preempted under the US Constitution's Supremacy Clause, which, as Sky touched on, in part says that the US Constitution and federal laws enacted pursuant to constitutional authority are supreme and override or preempt conflicting state law. The law of preemption is notoriously complex and it's less than crystal clear, but I'll just build off of what Sky has said and mention two of the key legal questions here. So the first is whether Congress, with the 2007's FDA Amendments Act, commonly called FDAA, ordered the FDA to create a pervasive, comprehensive regulatory scheme for mifepristone that precludes supplementary state regulation of Miffy. And the FDA has, of course, done just that with its uniquely comprehensive framework of risk evaluation and mitigation strategy, or REMS, which goes way beyond a normal drug approval and dictates in detail how Miffy is prescribed and by whom. The second legal question is whether West Virginia law poses an obstacle to the accomplishment of the goals of the federal statute. And West Virginia law, which imposes more restrictions on how Miffy is prescribed than the FDA's REMS framework, of course obstructs the goals of federal law. GenBioPro's challenge is narrow, and it's based on Congress's intent to regulate mifepristone specifically. GenBioPro points to a provision of the 2007's FDAA that expressly requires the FDA to provide safe access for patients to Miffy and about a dozen other drugs. In January 2023, at the same time that GenBioPro filed its suit against West Virginia, an OBGYN in North Carolina named Dr. Amy Bryant filed a challenge of her own against the state of North Carolina, challenging its restrictions on Miffy. North Carolina's law is less extreme than West Virginia's, but it nonetheless restricts access to Miffy, such as by requiring in-person dispensing and administration of the drug, and prohibiting prescriptions by nurse practitioners and other non-physician prescribers.
So Claire has beautifully described what these cases are about legally, but what are these cases really about? It seems pretty clear that GenBioPro and Bryant aren't interested only in West Virginia and North Carolina. GenBioPro is one of two generic manufacturers of mifepristone. It is trying to protect its market, its revenues, and protect abortion access across the country. GenBioPro's press releases and other statements make clear that it wants its West Virginia litigation to set a legal precedent that applies to all other states with mifepristone restrictions and invalidates their bans and restrictions as well. GenBioPro has assembled a very high-powered legal team, first with Democracy Forward, and then Kellogg Hansen and Arnold and Porter, that first developed this preemption theory. Dr. Amy Bryant is one very brave doctor who is trying to vindicate the interests of other clinicians and patients in North Carolina and around the country. She is not working alone. She is connected with reproductive rights organizations in North Carolina and around the nation. And she's also getting free legal help from two of the biggest and most expensive law firms in the country, Arnold and Porter again, and King and Spalding. So all of these lawyers seem to be working in collaboration and in concert with a broader coalition of organizations, including the ACLU, Planned Parenthood, ACOG, and more. And so Doctors for America is part of that coalition supporting GenBioPro, and it filed an amicus brief in GenBioPro's case as well, which we will discuss further in just a second. So what are the probabilities here? Both GenBioPro and Bryant won partial victories and partial losses at the trial level. Bryant won more of a victory. Part of North Carolina's law will be struck down unless the judgment is vacated or reversed on appeal. The trial judge in Bryant held that the provisions of the North Carolina law that require physician-only prescribing, in-person prescribing, dispensing and administering, scheduling of an in-person follow-up appointment, and non-fatal adverse event reporting to the FDA, all of those stand as obstacles to the Congress's purpose in creating a comprehensive federal regulatory scheme for higher risk drugs run by the FDA and are therefore preempted and invalid. So this is great news. However, North Carolina Republicans have appealed their loss, and that appeal is still pending. The Fourth Circuit announced that it will hold the Bryant appeal in abeyance until the Gen Bio Pro appeal is decided. So the Gen Bio Pro decision will come down first. So by contrast, the Gen Bio Pro case did not invalidate any meaningful parts of West Virginia's abortion ban at trial stage. So Gen BioPro also appealed to the Fourth Circuit, and its appeal is pending. Oral argument for that case was held on October 29th. And one of the judges that heard that case, Judge Harvey Wilkinson, pushed back on the federal preemption argument, but is not clear at all how much that will control the outcome of the appeal. So we will have to wait and see how the Fourth Circuit responds to those cases. Lawyers for Gen BioPro and Bryant were both very clever to file in West Virginia and North Carolina specifically, because both of those states sit in the Fourth Circuit, which is a federal appeals court that is relatively less conservative than most of the other circuits containing these abortion-hostile state legislatures. So if the Fourth Circuit makes good precedent on these questions, that precedent may make it harder for other states with hostile legislatures and governors across the country to restrict access to mifepristone. So the outcome of these two cases may ripple across the country to Louisiana, to Missouri, and to many other states with restrictions on mifepristone. These legal questions very well could go to the Supreme Court, which has the final word, but the First Circuit to weigh in on these questions will be the Fourth Circuit.
Great. Thanks, Isaiah and Claire. So I'll close the clinic's presentation with a brief discussion of what doctors can do, what clinicians can do, what the call to action here might be. First, let me briefly explain what DFA has already done. In February, the clinic filed an amicus brief of Doctors for America in support of Gen BioPro in its appeal. That's challenging the West Virginia law. And then in October, we filed another amicus brief of Doctors for America in support of Dr. Amy Bryant and her challenge to the North Carolina restrictions. My clinic, the Science, Health, and Information Clinic, filed these briefs with wonderful co-counsel at the law firm Goodwin Proctor. We all did this pro bono. In Doctors for America's briefs, we argued that to let West Virginia's and North Carolina's restrictions on mifepristone stand would undermine the stability and uniformity of drug regulation and medical care across the country. If states start to think that they have leeway to override the FDA, they may move to restrict or ban other politically controversial drugs, such as opioids and HIV PrEP, and more. And many elements of our healthcare system that rely on national uniformity, from prescribing guidelines and standards of care to telemedicine to medical education, will be threatened, and ultimately patients will suffer. The FDA is not perfect, as DFA knows well, but I think, and I think DFA thinks, that we do better with the FDA calling the shots on drug approval than 50 state legislatures. That's a very high-level summary of DFA's amicus briefs. I'm glad to talk more about them in Q&A if folks are interested. Very briefly, I want to acknowledge the Goodwin Proctor lawyers who worked on these briefs with us, Will Evans, Sam Jandal, and Brian Burgess, and 3 students who really drove the conception and development of these briefs, now alumni of the clinic. Those were Matt Tracy, Emily Davidson, and Nora Franco. As I think Isaiah and Sky and others said, we're waiting to see what the Fourth Circuit does. We could get a decision any day in the Gen BioPro case, although I think the court is likely to take months. So let me talk a little bit about other things that doctors can do besides watch these cases. One option is target the FDA, continue advocacy directed at the FDA to roll back restrictions on MIFI, or at very least hold the line. The less restrictive FDA's REMS on mifepristone is, the more likely courts will strike down state-level restrictions. DFA was a part of past advocacy that I know Sky had a big role in. Past advocacy directed at the FDA to convince the FDA to remove unnecessary restrictions on mifepristone in the past. On the flip side, as Sky sketched, there's a real risk that the FDA under the Trump administration could go the other direction and reinstate unnecessary restrictions on mifepristone. That's really important work, I think, to get involved with to resist the reimposition of medically unnecessary restrictions, and at very least ask the FDA to hold the line on the current level of access that we have to mifepristone in the US today. Another option for doctors, advocacy option in states with restrictions on mifepristone, is advocacy and public education around the Bryant decision. So note that the district judge, who doesn't have the final word, but she struck down restrictions on mifepristone in the state of North Carolina. Getting the word out about that, her view of the law, which may end up being the ultimate view of the law, might help to chill anti-choice legislatures, governors from legislating new restrictions on mifepristone. Doctors can also put the Bryant and GenBioPro cases and put restrictions on mifepristone into broader context, as Doctors for America's amicus briefs did. Access to mifepristone is vital, but even more than access to Miffy is at stake here. I said before, there's a slippery slope. If states can ban abortion drugs, they can ban other controversial drugs too. To quote the trial judge in the Bryant case, while that case concerns the distribution of a drug used to terminate pregnancy, a similar case could arise over any drug, from FDA-approved thyroid or diabetes medications, drugs for cancer treatment, vaccinations, contraceptives, or opioids. We don't want a 50-state patchwork of drug approvals in the US. So doctors, I think, can do op-ed writing and other public education about the dangers of letting state legislatures supplant the FDA's expert decision-making on drug approvals. Very briefly to that end, the legal team at SCHC is preparing for DFA a one-pager, a short document on preemption with talking points and further information about this kind of risk to our healthcare system. We hope that DFA advocates will use this document in conversations, in writing, and other advocacy. Keep an eye out for it. I think Sophia and Shreya and others at DFA involved with the FDA task force will be able to share that resource once it's ready. Okay, the last thing, of course, to keep this work going, the way doctors can get involved is join DFA if you're not already a member, support DFA, join the task force. Okay, that's enough, I think, from us. I'll turn the mic back to Shreya, and I'm eager to hear folks' questions.
Thank you so much, Claire, Isaiah, Chris, for your overview of the GenBio and Bryant cases and DFA's work in this area. We'll transition to the question and answer session now. We have about 15 minutes left. We'll start with some structured questions and then take audience questions as well. So first question. So regarding federal preemption, if restrictive state laws on mifepristone prevail, what precedent does this set for state interference in FDA-approved drug access, and how might this shape the landscape for medications addressing stigmatized and politically sensitive conditions? I know we touched on this a little bit.
I'm happy to start with that and then let the Columbia and folks also speak to it. We do view what's happening in the states here as really far more, not that we need it to be more, because abortion access and reproductive health care access is so essential, but we do view it as far more than just what is happening with these medications. You can imagine a pretty nightmare scenario where 50 states across the country seek to impose their own regulatory structures, impeding what Congress has long established in terms of the one regulatory body that is the expert regulating food and drugs in this country. And so we do view the implications as being quite stark, not only for reproductive health care access, but for our overall regulatory structures as a whole. I will tell you that I think there's a bit of a double-edged sword that we need to, or not, maybe it's not a double-edged sword, maybe it's just sort of like a opportunity to sort of exploit hypocrisy of anti-science sort of activist groups that are out there, because you'll see that the discussions around, for instance, the Comstock Act or other types of federal restrictions, you know, there's never an effort in this anti-science dialogue, of course, to really balance this sort of claim around state power with these other claims around the types of federal restrictions that one may seek to impose. And so I think that's something that we're watching. But certainly we view this as something that's far bigger than just mifepristone access. Although I will say that mifepristone, and I think this comes across in the GBP case and in the Bryant case, does have a very specific regulatory structure that Congress, specifically intended for a very narrow class of medications. It's quite clear that that was what was intended. But we do think that this, if a state, of course, could obstruct even that very specific structure, what it could mean for other types of medications or treatments is quite concerning, particularly for many of us who have family and communities in states that are restricting access to this type of treatment.
Great, thank you. Our next question is, what is SCOTUS likely to do with the preemption issues presented in GenBio and Bryant? Do we at CHIC want these appeals to get appealed all the way to SCOTUS?
I can jump in on that, although I bet Skye and others may have thoughts. I'll say briefly, first off, I'm not totally sure what the Supreme Court will do. I think it's a really critical question. First off, remember that the Supreme Court doesn't have to take every appeal. I think because the GenBioPro and Bryant cases are so important because of their impact on access to abortion, important because of their ripple effects on drug regulation generally, and important because they set a key precedent on the law of preemption, which is an important part of constitutional law. I think the Supreme Court is likely to take up one or both of these appeals. I'm sure that lawyers at GenBioPro and lawyers for Dr. Amy Bryan are thinking about how to tee up this case for the Supreme Court. While there's a majority on the court that's obviously hostile to abortion, that signed on to the Dobbs decision, I think there's some real reason for optimism on this issue. Partly based on what Skye just said. There are justices, including conservative justices, that have endorsed a strong theory of federal preemption of state law in other contexts, and to refuse to recognize that federal law preempts state bans on mifepristone would have ripple effects across other areas of law that they may be reluctant to create. Those are my initial thoughts, at least.
Yeah, I guess I'll just add to that. I agree with you, Chris. I mean, for those of us, and I know Chris is one of them, that have been setting this for some time. There was a case, and it's not entirely analogous, and so I'll just say that it's not entirely analogous, given that we actually think the case here for preemption is quite stronger. But there was a case when the Supreme Court had a different composition, when the more moderate to liberal judges had the majority on the court, known as Wyeth v. Levine, where the court considered a state tort law regarding liability that could extend to a drug manufacturer, to a pharmaceutical company, for injuries that an individual sustained that she alleged, Miss Levine alleged, was as a result of a failure to warn of a particular pharmaceutical product. At that time, it was the conservative and pro-business community that was, of course, advocating for a notion of federal preemption that stood for the proposition, and the Bush administration at the time at FDA sort of adopted this proposition that FDA's regulation, of course, was the final word, and because FDA had found the warning that the medication manufacturer had issued as sufficient and as accurate, that there was no state liability. There are different facts here, and I'm not suggesting at all that Wyeth is at all analogous to what happened here, but I'm using this as an example for where sort of the ideological lines were drawn at the time, because it was actually the court's conservative minority at the time that adopted a very full-throated version of preemption, one that frankly extends even beyond the facts of the Bryant or the GBP cases here. And so if there's any type of ideological consistency with that with that particular piece, with that particular side of the court. You would expect, because frankly, the preemption arguments here are quite stronger than they were in Wyeth, and there are lots of ways you could distinguish Wyeth. Because of the specific regulatory structure that is very specific and very narrow that Congress specifically intended with respect to the class of drugs that mifepristone belongs in as a result of that 2007 legislation that Claire mentioned and previewed earlier in the conversation tonight. So I would just say that it is possible that these do at some point get up to the court, and I think that this will be another place where there'll be a real question around the ideological opposition to abortion as medical care, at the same time, a very long-standing and longly held belief by those that are on the majority of the court now around the role that preemption and plays, particularly in the pharmaceutical context. And then, of course, even for those that may have thought that Wyeth, which was a case that was decided against the preemption side, was rightly decided, even those attorneys and advocates, including in the GBP case, one of the lawyers was counsel for Miss Levine, and is on the side of preemption in the GBP case because of the specifically narrow and very strong case for federal preemption in these cases. So I think we're all very attuned to where this could go with the court, and it will be quite interesting to see how the court might handle these cases.
Thank you for those thorough responses. Next question that I'm going to pair with one of our audience questions. Looking ahead to the new administration, how might shifts in federal leadership influence the regulatory and legal landscape for mifepristone and other FDA-regulated drugs? And an audience question we got is, how does removing the role of experts with the Chevron deference pose an Achilles heel to supporting experts like the FDA, and how can we at DFA bring back expert credibility?
Chris, do you want me to start and then you maybe talk about DFA's role? Would that be a good place to start? So let me say, I'll say two things. I want to address the Chevron piece, but let me just address on the sort of Trump administration, what we're expecting. We don't know until we truly get in. Of course, if you read Project 2025 and you take sort of the past as prologue and some of these groups at their word, there are many reasons to be quite concerned, and including efforts that we've seen at the state level, in the cases like the AHM case, which are backed by a lot of the same groups that are going to have quite an influence on the new administration, to politicize our federal experts into our federal process. That said, we certainly hope that the Food and Drug Administration will continue to do what it is supposed to do under congressional authority, which is to follow the evidence and follow the law, and to seek to make healthcare as accessible and safe to as many Americans as possible. I'm just plugging in my. So that's just number one. But if you take sort of the new administration at its word in Project 2025, we're in for a really, concerning time where there might be efforts to politicize the institution and to undermine the FDA's, independent assessment of science and evidence, which of course has led to a reasonably accessible regime where people can access mifepristone. So that's on the one hand. In terms of the Chevron deference case, the reason I wanted to just make a quick remark here, and then we'll let Chris speak, is that at Democracy Forward, we had the privilege of representing several scholars in the medical context that actually weighed in this companion case to the Loper Bright case, the Relentless case, about the particular implications that the Supreme Court's decision to overturn and Chevron deference, which for those that have maybe not been following this development, essentially is a longstanding doctrine that really deferred to, in some instances, the subject matter expertise of federal agencies and those employees that are at the agencies that are subject matter experts, as opposed to having district court judges that, love lawyers. I am one, but that don't have a lot of this expertise to sort of opine on these very sort of subject matter heavy interpretations. And we specifically flagged in these briefs, and it was picked up in some of the dissenting opinions in those cases, the concern that we could see. Should there be sort of a large scale effort at on the legal landscape to have judges substitute their judgment for the judgment of experts and subject matter experts, including at the FDA, and what that could mean for medication and food and drug regulatory structures. And so we're quite concerned that the Supreme Court has, of course, shown in its last decisions, has really, I think, undercut the expertise of those federal agencies in some ways. But of course, understand that all cases have to be decided on the facts as they exist, and do believe that there is a range of reasons that the court should continue to defer to both FDA scientific judgment, as well as a lot of the fact finding that they do that's really not subject to this new kind of legal regime. But I'll let Chris talk about what DFA can do. But I'll just say, I hope you all do a range of things, because we do know that the voices of physicians, and particularly the voices that Doctors of America has been able to bring to bear in many of these cases, has been super essential and really has changed a lot of outcomes and created much impact. So, but Chris will have some more thoughts on what DFA can do.
Jump in quickly because I know we're approaching the hour, but I enthusiastically echo and sort of +1 Sky's comments. And she and Democracy Forward have done just amazing work on administrative law across the whole regulatory state, before and after this decision, this Loper-Bright decision that has undone Chevron deference. Very quickly, I'll say, I don't think that the Loper-Bright decision and other things the Supreme Court did in the last term mean the end of regulation or the end of the administrative state. They're bad decisions and they hurt regulation, but they don't completely destroy it. And I think some of the kind of commentary has suggested that, and I don't think that's right. There's a lot that the FDA can do, and a lot that lawyers and advocates supporting the FDA and other regulators can do to protect the work that they do. And I think our work on preemption is kind of part of that, protecting the authority of the FDA in the face of states that try to undo that authority. On what doctors can do, thinking about, we're trying to protect not just the authority of the FDA, but the integrity of the FDA. And that's going to be really important in this new administration. I think through, all administrations, Doctors for America has been really focused on holding the FDA accountable. So wanting the FDA to be a strong central regulator, but then wanting also to scrutinize its decision-making. And I think about, the amazing work that DFA did on Makena, on muscular dystrophy drugs approved by Sarepta on the basis of really meager evidence. And in the early days of COVID, I remember DFA kind of reminding the FDA that it is supposed to be independent. This was in the first Trump administration, reminding the FDA that it is supposed to be independent of HHS in many important ways, independent of the White House, that it has its own sort of statutory and regulatory mandates, its own decision-making processes. It's an independent agency, and I hope that in the second Trump administration, it will continue to be. And there's great work that advocates can do to kind of hold up the best version of the agency and support the terrific scientists and civil servants who work in the agency, and I think want to continue doing good work no matter who's in the White House. So long-winded way of saying lots of advocacy to come, but DFA is really one of the leaders in this work.
Thank you so much. In the interest of time, we will start wrapping up this Q&A session. I just want to end with one last question, which is if you all have any final concluding thoughts about the role of physicians and clinicians in the advocacy for this cause.
I guess I'll just say, I come at this, I'm now the president and CEO of Democracy Forward. And as a lawyer, we've had the privilege at Democracy Forward of representing so many physicians and physicians groups, but even beyond my experience at Democracy Forward as both the former general counsel of the American College of OBGYNs, and then as a private corporate attorney that spent a lot of my pro bono time representing physicians and medical professionals in a range of cases across the country, I can say that I believe that there is truly no other voice that on these matters of healthcare that is more important than the physician healthcare professional voice. I have seen in case after case, at district court levels, in comment after comment, at regulatory levels, at the state level and at the federal level, at courts, all the way up to the Supreme Court, the voices of physicians matter. They are truth tellers. They call it like it is, with what the science and evidence says, whether that is a popular position or an unpopular position. There were times that many of the positions that the physician organizations that are now getting praised for much of their advocacy that is seen as sort of chic and new, there were times in the past that that was not necessarily the popular view, but it was the physician and research and scientific voices that would always be willing to stand up and tell that truth to the courts. And it's going to become even more essential and important as we continue to move into an era of American life in this country that is unfortunately defined by disinformation and misinformation in so many ways, to be looking at those people and communities that are really the truth tellers and that can hold those facts and evidence for all of us. And so I will just say, I believe that there is really no other powerful voice, no other voice more powerful in this moment, especially with respect to healthcare matters, than those in the communities that are providing care to patients every day, and that can both leverage their professional and learned experience in those individual encounters, as well as their sort of more aggregate and professional experience in the research and science and evidence. And we see evidence of that in our work every single day. And so I just want to, that's why I always love doing these webinars, and I'm so grateful to get to be in community with you. But I think that this is going to be even more of an essential time for the medical community to leverage its voice and its expertise, and to be there on the front lines of so much of this work.
Yeah, echoing everything that Sky just said, especially in light of the additional challenges coming our way with the new administration, clinicians' active involvement is more important than ever. And as a clinician, there's actually a lot that can be done. As Chris mentioned, you can advocate for the FDA to roll back its REMS restrictions on access to MIFI, or at least to hold the line. You can educate other clinicians and the public on these cases, such as through writing op-eds or other informational materials. And if you want to get even more involved or potentially collaborate on some policy or legal projects, you can reach out to Sophia to join DFACE's FDA task force. Or you can come to more of these advocacy grand rounds to learn more about what you can do.
Great, thank you all, and thank you, Sky, for those powerful words. I think there is so much to be said for having integrity and telling the truth in this time of misinformation. And I think just it's amazing being here tonight, seeing the collaboration that's happening between professionals in the medical field, the legal fields. And I know I'm speaking for myself in saying this is giving me a lot of optimism for the future during a very uncertain time. All right, well, it's, getting to the time to wrap up tonight's session. So I just want to provide a quick recap. Today we highlighted the urgent need to educate physicians on state legislation restricting mifepristone use in conflict with the FDA's REMS, emphasizing the critical role of federal preemption in safeguarding equitable drug access. Our speakers discussed how upholding restrictive state laws could create dangerous precedents, limiting access to other essential medications such as PrEP and opioids, while causing widespread harm to the medical profession and patients. The case of Bryant underscores the importance of challenging these laws, and physicians are encouraged to actively advocate to protect evidence-based practice and patient care in the future. I'd like to close by thanking our speakers for such a thought-provoking and educational discussion. A lot of these are very complex legal cases that we're discussing, and I think you all made it extremely digestible for just, a lowly physician like myself. We're so grateful that you're able to join us. Before you leave, here are quick reminders for everyone. Education is important, but so is action. I think we've talked a lot about potential actions you all can take tonight to further this cause. So please continue to support DFA and stay connected with our work on mifepristone and federal preemption. Share what you learned tonight with friends, colleagues, legislators and policymakers, and conversations, op-eds, and more. This session tonight is being recorded, so we're also happy to provide a recording to anybody who would like to share it with a particular colleague or group and make a further impact. Also, please be on the lookout for the one-pager that I believe Chris previously mentioned on the Gen Bio Pro and Bryant cases from DFA that are coming soon. Advocate for the FDA to roll back medically unnecessary REMS restrictions, as we have mentioned. And again, invite others to join DFA in this work. Please watch out for additional opportunities to provide input on future policy issues. And for those of you that are paid sustaining members of DFA, please complete the survey for a credit of CME for attending this session. A link has already been put in the chat. And lastly, if you enjoyed this advocacy grand round session, please consider donating to DFA's work and making a financial gift. Thank you all for being here and for all that you do on behalf of patients. We hope you'll become an official DFA member and take a look at the benefits on DFA's website. Again, we're putting a link into the chat to sign up. You can get a 20% off your first year of membership by signing up today with our promo code ENGAGE in all caps. The #1 reasons doctors, medical students, and health advocates join DFA is to be with like-minded people that share the same values and priorities, and I think tonight's session has really highlighted that. Also, please follow us on Twitter, LinkedIn, Facebook to stay up to date with all of DFA's programs and future events like this. Thank you so much for attending, and I hope you all have a great rest of your evening.